Hello, everyone. Thank you for joining us. We'll give everyone a minute to just kind of file into the room. I see the participant number going up, which is always exciting. People are actually showing up. Just so the participants are aware, you will be on mute the entire time. We can't hear you. We can't see you. So if you do have comments or questions, I think everyone is a Zoom expert now, so you can put those in the Zoom chat or in the question and answer box if it's a question for our panelists today. So I think it looks like we've topped out our participant number. So welcome again, everyone. This is a CLE Managing the Risks and Rewards of Trade Secret, a guide for in-house counsel in coordination with ACC Georgia. We're really excited to be here today and to talk to you about trade secrets. A little bit of housekeeping issues. We're working on the CLE accreditation, and so there'll be more information to follow about getting the certificate, but basically what we're going to do is partway through the program, there'll be a code word. That's the word that you'll need to copy down so that we know that you're really out there and watching. And then you'll need to email my firm's contact that's setting up the CLE. So that's Ellen Hotter, and her number, or her email address is EHOTTER@Willenken.com. And maybe Ellen, if you can just drop that in the chat actually, so people can refer to that. And so again, in order to get your CLE, which is in progress, and there'll be more information following up, but you do need to copy down that code word that we're going to say about 10 minutes in, and send an email out to Ellen, which Ellen, if you can drop your email address in the chat, that would be great. So without further ado, let's get started. Again, this is Managing the Risks and Rewards of Trade Secrets, a guide for in-house counsel. Our panelists today, there we go. Our panelists today, we have Carol Forsythe, Executive Vice President, General Counsel, and Corporate Secretary and Chief Compliance Officer of Air Lease Corporation. And we have John Haraldson, General Counsel of Lynx Franchising LLC, perhaps better known to some of you as JanPro. And myself, my name is Amelia Sargent. I'm a partner at Willenken LLP. Willenken is a trial and litigation boutique in Los Angeles, California. We have a nationwide reach, and we're really thrilled to be here today talking to you about trade secrets, which is one of my favorite topics. So just to turn it over real quick to Carol, maybe to introduce yourself and tell us a little bit about what your business does.
Hi, everyone. I'm excited to be here. Thanks for participating. Air Lease Corporation is an aircraft leasing company. We own about 23 billion of commercial aircraft, and we lease them to airlines around the world. I know this is Delta country. We do lease to Delta, although Delta owns most of its planes, but it's always surprising to people that about 40% of the aircraft flying around the world right now are leased to the airlines, and they don't own them. And that trend is going up. And so, like John, we're a little bit in the middle of this pandemic. And when you hear about what John does, you'll know why he's in the middle of it too. But I am on this call because I am a victim of a trade secret lawsuit.
Thanks for joining us, Carol. All right, and now John, can you tell us a little bit about what you do? Oh, John, you're on mute.
Very good, great. So I'm the General Counsel for Lynx Franchising. We are a platform franchise company with 3 different brands. Most well known is JanPro. We do commercial cleaning. Our unit franchisees do commercial cleaning. I have to be very careful about that because we have employer and independent contractor issues around that. The second brand we have is First Team. They do restoration work for fabric and electronics in the event of a disaster, flood, or fire, typically what you would see. And then the last of our brands is Intelligent Office. So they lease out office space, and they also provide virtual assistant and telephone services. And so we are fortunate that all of our businesses were designated as essential throughout this, but we've been incredibly busy. So.
Okay. All right. Thanks, John. And there's me. That's a great picture. Not really. Okay. So today we're going to be covering a couple of topics. We're going to start by going through some background and definitions of what is a trade secret. I'm going to take the lead just describing the legal framework to remind you a little bit about where trade secrets fits in among the other categories of intellectual property. And then we're going to get to really the meat of our today's presentation, identifying and protecting your business's trade secrets. And that's where I'm going to turn to John and Carol a lot for their great insights from an in-house perspective. And then we're going to end with a little bit of a litigation primer on kind of do's and don'ts of what might happen if you face a trade secret lawsuit, again, from an in-house perspective. So again, if you have any questions, there'll be time for questions at the end. You can use the Q&A box, and I do have it up on my second screen, so I will see it. And if you have any other questions or sort of troubleshooting, I should have mentioned this before, troubleshooting in terms of tech, there's sort of very little we can do except ask our presenters to speak up. So probably if you're having an issue, it might be, you know, your end and not ours. So you might just try logging in again, or if you need to, reach out on the chat and we'll see what we can do. But again, sort of thanks everyone for joining, and we'll start off with some background and definitions. So when we're talking about trade secrets, we're talking again about intellectual property, one of the categories of intellectual property. That refers to loosely sort of creations of the mind, inventions, literary and artistic works, designs, symbols, names and images used in commerce. Those might be the things you think of when you think of intellectual property. As you'll remember from law school, intellectual is protected by copyright, trademark, and patent and trade secret. Not all creations qualify for legal protection, but if they fall into one of these categories, they can be protected by law. So just to kind of break out the different types of intellectual property so we can really focus in on trade secret. I put up here on this slide, I'm not going to read it thoroughly, but the standard for patent, a new, useful, non-obvious invention. In order to get a patent, of course, you have to disclose the invention to the government. And in exchange for that disclosure, you get a period, sort of a monopoly period of use on that invention, right? So on here, we have limited to 20 years from the date of filing. That's the protected period under the patent regime. Copyright, you might remember, is a creation of an author, and it gives you the rights of the originator or assignee to print, publish, perform, film, any sort of authored work. And again, in order to get that protection, at least in order to get the most robust type of protection, you have to disclose that copyrighted work, you publish it, and in exchange, you get a certain amount of legal protection, the life of the author plus 70 years. Similarly, for a trademark, that's going to be, you know, your brand, your mark, your sign, design, or expression that identifies your products or services in commerce. That, again, you have to register in order for it to be protected. And there's no time limit, but you do have to keep renewing your registration for federally registered marks in order to get protection. Trade secret is a little different, and that's the focus of today's information. Trade secret has as its general attributes any information that's not generally known within the industry, that provides an economic advantage, and that the owner uses reasonable efforts to maintain its secrecy. There's no disclosure required. You don't disclose your trade secret to the government. You don't register it. You don't tell anyone about it. That makes it very different from other kinds of IP, which require a disclosure in order to get protection. Instead, it's the secrecy that, that kind of governs whether or not it's protected by law. And protection can be indefinite here, so long as the secrecy is maintained. And so it can last quite a bit longer than patent, for example, which is why some companies choose to go with trade secret protection instead of patent. Trade secret protection the regime is under a common law. There's the Uniform Trade Secret Act, which most states have codified some form of the Uniform Trade Secrets Act, except New York. There's some state-by-state variation. And more recently, there's the Federal Defend Trade Secrets Act. I put some information up here. It was signed into law in 2016. And it's actually an amendment to the Economic Espionage Act. So it's an amendment to a criminal statute, but it provides a civil action for theft of trade secrets that are related to a product in interstate or foreign commerce. So just to drill down a little bit on the specific requirement of a trade secret, going to the DTSA, again, the Federal Defend Trade Secrets Act, trade secret is defined as all forms and types of financial, business, scientific, technical, economic, or engineering information, right? So it's information of almost any kind. Then in the highlighted magenta color, whether tangible or intangible. So it's all forms and types of information, whether tangible or intangible, if the owner has taken reasonable measures to keep such information secret. So you've got to keep it secret. And the information derives independent economic value, actual or potential, from not being generally known. And it continues on, known and not being readily ascertainable through proper means by another person who can obtain economic value from the disclosure or use of the information. So again, the information has to be subject to reasonable measures to keep it secret, and it has to have economic value for being secret. So I like to think of it as competitively sensitive information, information that your competitors would get value from knowing. The DTSA and the UTSA, the Uniform Trade Secrets Act, prohibit misappropriation of trade secrets. Misappropriation is defined in a number of ways. Acquisition, disclosure, or use of a trade secret via improper means, or in violation of a duty to maintain its secrecy or limit its use. Improper means is pretty easy to conceptualize. It means theft, bribery, misrepresentation, a breach of a duty to maintain secrecy, or espionage through electronic or other means like hacking. And violation of a duty to maintain a secrecy or limit its use, that would be like an officer or director's fiduciary duty to the company to keep its confidential information confidential. It could be an employee's duty of loyalty, depending on how strong that is in your jurisdiction. And it could also be contractual duties. For example, an employee handbook, an NDA, or a license. And those are very powerful tools. And we'll talk a little bit more about that in the next section. So probably when you learned about trade secrets in law school, if you did, you learned about the classic examples. I have on here the Coke formula and the KFC chicken recipe. And it's true, for recipes in particular, recipes and formulas are commonly protected by trade secret because they're not able to be protected by patent. But just by keeping them secret for so long, corporations that do use the trade secret regime are able to have basically indefinite protection on their trade secrets. So now here's our CLE code. I was told to pick a ridiculous phrase that people would remember, so I picked grape soda. So jot it down, grape soda, email to Ellen Hodder. It's in the chat to be sure so that we can set up the CLE credit. So now we're going to go to identifying and protecting your business's trade secrets. And I'm going to turn to my panelists. Before I do see a quick question. If not codified in New York or DC, how are trade secrets governed there? That was a question in the chat. It's an easy answer, so I'll just answer. The Uniform Trade Secrets Act has not been codified. That was a uniform law. There is a common law regime. I think there is a common law regime in New York. It's just not the Uniform Act. And then also federal law. Okay, identifying and protecting your business's trade secrets. So here we can think about, what are the business's trade secrets? And going back to the two prongs that define a trade secret. What is the competitively sensitive information and how is it kept secret? So now I'm going to turn to my esteemed panelists. Let's start with Carol. Carol, how would you go about identifying your business's trade secrets?
Well, it's an interesting question because sometimes when you start this conversation, people aren't sure that they actually have them. And you have to go through and really drill down with your team on what is competitively sensitive, and also, was it protected? So you do interviews. You really try to focus in on your core issues in your business. We're an aircraft leasing company. We have very important contracts that are kept secret, as well as processes to engage in with our customers as well as our suppliers. So you really have to do a disciplined look at it and identify, and then quite frankly, throw some things out.
John? Here, I'll turn to the next slide. Here are some examples of trade secrets, if you could speak to these.
Sure. So I tend to think of trade secrets in sort of two categories. One of them are sort of your static trade secrets. So like the formulation of Coke sort of remains the same, processes, things like that. And then I think also what I call dynamic trade secrets, which are, maybe current marketing plans, some financial information and other things. And you protect each of those a little bit differently. And, so for me, it's sort of helpful to kind of break those down, and then you sort of have different regimes as to how you look at and identify each of those. But obviously, the gamut of what constitutes a trade secret can be fairly broad, whether it's, a customer list that has a lot of historical information with it that's valuable, or if it's a business process, as in, for example, there's a particular way in which you would clean an office that may give you a competitive advantage over somebody who doesn't know how to do it that way, that maybe you're more efficient. It'd be any number of types of things like
that. So I put up on this slide here, I think sometimes, when I've done this presentation, sometimes people are really surprised at the breadth of different types of trade secrets that your business might have, right? So as John pointed out, it's not only going to be maybe your core business, the Coke formula or the KFC, secret spice blend. It can be business and marketing plans. It could be a plan for expansion into an area where your competitors, aren't there yet. It could be a budget or a financial projection. It could be a software process that you've created to help you in your business, but is a proprietary shortcut that you've created to make something easier. As John mentioned, a compilation of data like a customer list compiled with their preferences that you've learned over time. Pricing and vendor information is another. Pricing is a quintessential trade secret in the law, so that's really key. If you have a pricing that's not generally known and not published, but that you have negotiated with your vendors. Product specifications, prototypes, all of these things, sort of, especially in the pre-patent world, if you're not going to go out and get a patent right away, it's protected by trade secret. And then negative information, how not to do something. Again, if you've learned it, if it's information and it's integral to your business in some way and it's competitively sensitive, it can qualify as a trade secret.
And Amelia, an example of that in our situation is how we track our customers who aren't paying and how we do it and the way we manage that process, that can be seen. It's negative information about the customers and how we're responding to it. And, you have one of those classic spreadsheets, and sometimes it just is such a part of the business that and it goes to a wide variety of people, and how are you protecting that can be an issue on negative information.
Right, exactly. A wide variety, you know, everyone can have trade secrets in your business, not just the core business, but your marketing department probably has trade secrets. Your billing department probably has trade secrets. And so, you know, when you're thinking to yourself, what are the business's trade secrets, you'll really want to, you know, interview, I'm going back to the slide, interview key stakeholders. What, you know, what do you use that make your business easier? What is potentially sensitive that we wouldn't want our competitors to have? Then the second piece of this is that Carol just alluded to is how is it protected, right? Because again, in order to get protection under the legal regime for trade secrets, the owner of the trade secret has to take reasonable efforts to keep the information secret. So in terms of that, we had a really interesting discussion in our pre-session about how it is that we could create a culture of protecting trade secrets. So just before I go to that slide, I wanted to ask John if he had any thoughts about how, you know, the undertaking these reasonable efforts to keep a trade secret secret.
Yeah, one of the things, and you know, we'll get into a little bit more later, but is really focusing on the education of your employees as to what constitutes a trade secret. You know, one of the things that in one of the places I used to work that people that really think about it that way, you know, we would send out marketing packages to our retail locations, and we would be having a sale, you know, like a discount that would be coming up in a week. So the manager would see the package, they'd know what's going on. Well, you know, there's in this case it was an oil change franchise, but you know, they would have somebody down the street they'd often go to lunch with, and the question is do they happen to accidentally mention that, yeah, we're having a $19.99 oil change special? Well, when they talk about that stuff, then the day before we're going to launch, the guy next door launches, and so all the people that would probably come into us go to the competitor, right? And so it's just like thinking about things like that, making sure those, you know, retail managers really understand how important it is that they not talk about that stuff. You know, and the same thing goes for your Twitter and Facebook accounts and other things, and you know, just sort of those innocuous things that you think you're saying that are okay, like, hey, we're a big project, or traveling to, you know, Philadelphia, and then, you know, people can start connecting dots. So
right, definitely. I have on this slide, there are some you know, best practices in terms of protecting your trade secrets. How do you educate your employees on what's a trade secret? You can use HR, you can use employee handbook. Management and training is a huge part, which we'll talk about on the next slide. You need to make information available on a need-to-know basis. From a litigator's perspective, I love to see documents in discovery that are marked with confidentiality designations. You might think they don't matter, but they totally do. You'll want to use your IT capabilities to maintain confidential systems. This could be as easy as password protecting sensitive information, making it available in a cabined way to only the people who need to see that information. Password protected documents, read-only documents that you're not allowed to print, for example. And physical protections. We're not really, we're very virtual right now, but you know, physical protections of keeping something under lock and key is still a major way to protect a trade secret. So I wanted to talk more about this culture and awareness of trade secrets, and I wanted to ask Carol maybe to jump in on how she does that in her company.
Right. I know all the in-house lawyers face this. You know, it's always, you look at it in hindsight, you have a problem, right? So you're sort of backing into it. You get some lessons learned, but just even though using the word confidential on a document, we've all been here. We're lawyers. We tell people all the time, mark it confidential if it's confidential. And, you know, you'll talk to your business people and you'll talk to people and they'll say, but everybody knows it's confidential. Why do I have to worry about sending this out with confidential? And, you know, so we all face this. How do you create a culture? And how do you change a culture that maybe didn't come from this world, right? So I had a company who had a trade secret lawsuit, and we'll talk about that, but it's even transitioning the culture. How do you get people to treat things as confidential, protected, realize that this effort is going to pay off if there's an issue down the line. We talk about educating, you know, you have to educate at a lot of different levels. Not everyone is dealing the same way, and you have to target your education with real live examples. And one of the things we have done at the company is, and it wasn't in the trade secret category, but it really plays out. We had a breach of contract lawsuit, and after it was over, we had the lawyers come in and talk about, you know, the bane of all lawyers' existence is email and communication. And they used examples that came up in the lawsuit about how email's used, how your text back and forth where maybe you're joking a little are used. And doing that kind of training, it was a revelation to people. They loved it. They really got it because it was about their business, how they conduct themselves. And so doing that kind of training really helps people start to think of this as something that they actually can make a difference in and have a responsibility to do it. So those are just some of the things that I think can be very valuable to in-house lawyers. At least they were to us.
Yeah, so one of the things that I always got complaints about was the training that we would provide is not relevant, because a lot of people will use like a generic LMS system, and we found that, you know, investing a little bit of time and putting together some specific training that is aimed at particular groups. So for example, if you're talking to executives, you may talk about a certain, you know, types of trade secrets and at a certain level. If you're talking to, you know, retail employees or people that are working on the manufacturing floor, you've got to make it relevant and also fun. In particular in retail, you need to make it fun. So if you can gamify it, do something that's fun like that, but use real world examples, you know, and a lot of times you can pull from your history, or you can, you know, find some good examples online that people can relate to. And I find that makes it a lot more engaging, and it sticks in people's minds a little bit. And then of course also remind them there are actually criminal penalties that attach to some of these things, and nobody likes an orange jumpsuit. So, you know, those are some of the things that, you know, as you're building that culture is, you know, be careful of making sure that you don't bore people to death, and that you know, do get, you know, at your right audience and at the right level.
Right. And from a litigator's perspective, I like to, sometimes when I've done this presentation, I refer to it as pre-qualifying your trade secrets. You don't want your litigators on the back end having to try to, you know, prove up that it's competitively sensitive, or prove up that it was reasonably protected. If you've done that ahead of time, it's so much easier to make that case in terms of protecting your company's trade secrets than if you're stuck on the back end trying to figure out, you know, well, what was taken? Was it really a trade secret? Could we make it count as a trade secret? You know, it's a little bit less desirable. I think the benefit too is if you're very proactive about defining your trade secrets, you can reassess what your trade secrets are on an ongoing basis, right? So not everything is going to be competitively sensitive forever, right? A budget projection is only going to be competitively sensitive until it's out of date, and then it kind of doesn't matter. And that lets you kind of focus in on, you know, what are you really worried about protecting, and what can be sort of declassified, right? After a while where there's less concern. So now we're going to go through a couple of best practices, and then we're going to talk about some red flag situations, again, with our panelists' great insights. I just wanted to go through these quickly, kind of what are reasonable efforts in the case law best practices in terms of your employees. I know a lot of times when people think about trade secret misappropriation, you think about hacking, you think about someone from the outside hacking in and stealing your secrets and making use of them in the global marketplace. But really, usually a company's greatest threat to its trade secrets are its own employees. And that's why the training is so critical, and creating that culture is so critical. So onboarding and offboarding are really key when you're taking on employees who may be coming from a competitor, or you're offboarding employees who may be going to a competitor. So some best practices include, being sure to provide the employee handbook, requiring a signed acknowledgement, making sure that they sign an NDA if you have that kind of information involved with their job. If a non-compete is enforceable in your jurisdiction, consider whether it's appropriate. Consider having the employee coming on certify that they're not bringing any confidential information from any previous employer, especially a competitor, and that they're not going to use it at work. That's going to protect the company. You don't want that stuff. You don't want a trade secret lawsuit when they come on board, and that's going to also signal to the employee that you do have this culture of enforcing and protecting the company and not using illicit trade secrets. And finally, being sure to log and record any equipment provided, phones, computers, laptops. I'm sure everyone here is very sophisticated and very good at this, but I have seen cases where people are not so good at this, and it really does help to keep a log of what people have in terms of technology and when they turn it back in. Then in terms of offboarding, again, reminding employees of their continuing obligations to keep confidential information confidential. It doesn't just stop when they stop working for the company. Ensure that they've returned all that company equipment. Again, that log, needs to have the equipment come back on it. That's what we like to see. Have them certify that they're not taking any confidential information and that they've returned or destroyed any copies of company documents in their possession, and shut off access to email and sensitive company information immediately. And this gives rise to our first kind of red flag scenario when an employee is going to a direct competitor. So we have some suggestions on here, but maybe one of our panelists would like to jump in on kind of the direct competitor scenario.
Sure. So I'll take that one to start anyway. A couple of things that that I've done in the past is if we know somebody is going to a competitor, we'll do two letters. One of them goes to the employee that's leaving, just reminding them of their obligations, spending a little bit of time outlining sort of what the scope of a trade secret is, what kinds of things that they can't use to benefit their new employer. A lot of times we'll also send a note to the employer. And in particular, if there's a non-compete that's in place, to make sure that you work through, the compliance with that. So that could be maybe they shouldn't work for them at all, or maybe that they have to have a specific set of defined duties, things like that. So I find that that's helpful, and most folks tend to be fairly receptive to that because nobody wants to be on the wrong end of a trade secret suit. And I think the other thing is if you are, getting rid of an employee, but you don't know where they're going, you want to make sure to include reminders of the trade secrets and confidentiality in the severance agreement if you do those.
Yeah, and in California, we don't have non-competes, so we don't have the advantage of that. And what we do both in the onboarding and the offboarding is really try to be as practical with the person as possible on all of the places you could have information about the company. We do a lot of training on just use your work computer for work and keep all of your information here, and you try to put all these processes in place so that they have a very robust portal to do their work back and forth in the company. But you also have to remind people about thumb drives and other things that could be, or did they forward something to their personal email? Because in hindsight, if you're involved in any kind of a claim or litigation, that's their aha moment. See, the employee did have our important information and it was on their personal computer, or they had thumb drives, or when you travel, we're an international company, we travel all over the world. A lot of people are still in the habit of putting something on a thumb drive to make sure that they have a backup when they get there, in case there's trouble with the computer and the like. And so there's a lot of places that this can come up. And when someone goes to a direct competitor, you also may need to do some training within your own organization, right? So we work at places where we have personal relationships with people. And then they may have, like we said, you know, Facebook connections or Instagram connections or do, you know, and that information can get out. And so sometimes you have to sit down with your key players in your own organization and say they've gone to a competitor, you know, we wish them all the best, but here's some things to keep in mind when you're dealing with that person, because you have such a more natural relationship that you may say, oh yeah, we can give you that. And it may turn out to be something that we would want to protect. So those are some tips that we do inside our company.
Yeah, great. Great. And this segues really nicely into our second red flag scenario, which everyone is now very familiar with, remote work in the time of COVID-19. And Carol already spoke to some of this because the nature for business being very heavily in terms of people working remotely and traveling. But you know, currently remote work, people are working remotely who've never worked remotely before and who aren't used to the good practices with that, and people are working at home on their personal devices. People are doing your company's work on their personal computers, on their personal Wi-Fi connections. Instead of secure offices, employees are working at kitchen tables with kids, spouses, roommates. You don't really know who's in the room. So Carol or John, can you speak to a little bit about either here, I'll have to go to the next slide about some tools available, but what has your company done in terms of COVID sort of remote work issues?
I can start, because really for us, as you said, it's a lot of the issues we had to deal with up front because of our travel. And so, you know, we have really focused in on the tools in the computer to keep our information safe. We have policies about remote working. We have people sign agreements on how they're going to remotely work. We're 7 months in California, and we have not been to the office in 7 months. So we, you know, even though we travel all the time, we had a scramble at the beginning too, and we continue to provide additional information. So this is a living thing. As you learn more, so we have agreements about how they're going to work. You know, 7 months in, people are a little stir crazy in California. They're starting to go sit at outdoor cafes or at coffee shops so that they can get a change of pace. And then we're reminding people about that kind of conduct. You can't do that while you're working on company business. We also generally don't want people using Wi-Fi outside. Our normal policy was don't use Wi-Fi outside the company or your home, right? We said when you go to a customer, don't use their Wi-Fi. We travel all over the world. Don't use the Wi-Fi when you get to an airport. We'd rather have you use cellular in places in the world because it's protected. So we're having to adapt a little. We're also, looking at, we've given for some high-level people even more protection on their Wi-Fi systems at home, and that'll live through this pandemic because we all work sort of 24 hours a day when we have customers all over the world. And we're also having people sending messages, collect up your sensitive documents, put them in a FedEx label, send them by FedEx. We'll have someone come pick them up, and we send them to the office to be shredded so that things aren't getting thrown out in the garbage. Those are just, one of a million things that we sort of are looking at and trying to constantly remind people about in a nice way that doesn't, that just sort of gets it into the DNA.
Yeah. And one of the other things too is obviously we've got, we're less remote here in Georgia, I think, than California. We're, in fact, our office, we're back to the workplace 3 days a week. But we do have, remote workers. We have offices in multiple places. And so when we look at document sharing, we use Dropbox. And one of the things that we've done and been very, very conscientious about is making sure that only certain people have access to certain folders. And so that could be for mere confidentiality type stuff, but it could also be for trade secrets as well. And so, this is, where you've done the work on the front end, identifying what the trade secrets are and what level they are and how long they last. You can then those boxes where you keep that stuff to only those people who need to have access to it, and not generally. And so I think that's another thing to think about is identify that stuff and you store that in sort of one place.
Right, that's a really great insight. If you've, because for the legal protection, you only need to take reasonable efforts. You don't necessarily need to take perfect efforts for it to be protected under the law. And so, it's a trade-off, right, of being able to conduct your business, but also taking those reasonable efforts to keep things secret. And if you've identified your trade secrets ahead of time, it can be so much easier. Another red flag scenario we wanted to touch on quickly, I think John had some insights here, particularly acquisitions, joint ventures, or quasi-joint ventures. John, do you want to speak to this?
Sure. A couple things on this one. One of them is, and most of the softwares, when you set up the data rooms, they track who's in it and who looks at what. And that's important information to make sure that you've limited the access and then you're tracking who's looking at it. One of the other things though to think about is as you're talking to potentially competitors who might acquire you, is to make sure that only the right people looking at, in particular, the trade secret information. So for example, if you've got a particular formula or product, do you in fact need to have their technical guy look at it, or can somebody who is maybe knowledgeable enough, but not somebody who's in the lab that can recreate it, taking a look at those kinds of things, just to make sure that you've properly protected it. And then also, obviously, make sure you have really strong agreements on, when you enter the non-disclosure agreements.
Right, definitely. I put a case in the slides. I'm not going to cover it now, but there was a very large jury award in an instance where an acquisition sort of went wrong or went south. And I would, if you're interested in that, I would definitely look up this case. Our last red flag, I'm just going to go through quickly. Offshore or outsourced operations, that's another scenario where, if you're dealing with trade secrets, you want to think about your offshore or outsourced operations and just how sending your trade secret overseas, who has access to it, if you've got offshore manufacturing, and who, how is that going to be protected? The DTSA, Defend Trade Secrets Act, does have some extraterritorial reach, but again, you'll just want to be mindful of how who has access to your trade secrets if it's going overseas. So our last topic is going to be something of a litigation primer, sort of if the worst case scenario happens and a trade secret lawsuit is in the cards. And first, we're going to start by asking, what do you do if you suspect that someone has misappropriated your trade secrets? When we discussed this in the rehearsal, we talked about really this preliminary question that you want to address, which is, do you really have a case? And I know Carol has some insight there.
Well, I think as in-house counsel, we know we're usually not the ones that have identified whether a trade secret's been misappropriated. It's worst case scenario, the CEO thinks it's been misappropriated, or a business person, right? Because then they come to you and they're like, well, you've got to stop this. This is outrageous. And it might even be something that earlier on in the conversation we talked about when you went to these folks and said, okay, what are our trade secrets? How do you feel about this and that? And you have these big discussions. They're like, oh, I'm not too worried about that. Suddenly, when it's been misappropriated, it is a trade secret. And so you really have to take a step back and ask yourself, going back to the front of the presentation, what have we done to protect it? And those are really hard conversations because, your business feels vulnerable, it feels attacked, and suddenly you're the bad guy saying, well, we did this, we did that, we didn't do, the like, and that's what makes these cases very hard.
John, do you have some insight to add?
Yeah, and I think one of the things, that I always, caution the executives on is to not take it personally, even though they always do. And, as the in-house counsel, you've got to be the one who's objective, even though you too may get really worked up about stuff, but you don't want to lead somebody down a path where, they're not going to end up being able to follow it, right? So, really do take a step back, be objective, look like is this really, does it fit the definition of a trade secret? Did we protect it? How far are you willing to go? Right? I mean, that's, how valuable really is it? Is it time sensitive? Is it going to fade in a couple of years or a couple months? Because enforcing this stuff, I mean, even, like a non-compete is supposed something similar. You can spend, tens of thousands of dollars. And if there's not a lot of value to protecting it, is it really worth it? Because at the end of it, they'll spend the money and maybe they won. They're like, but that was a waste of money. And so, you want to sort of build those expectations up front.
And it's always the most emotional when it's a former executive who's gone somewhere else. And it's very hard to maneuver those situations because of that sense of betrayal that your business team may feel.
And that's absolutely, from a litigation perspective, the cases that do end up in litigation often do have so much kind of emotion behind them of an employee or an executive who's gone to a competitor or started a competitor. And that sense of betrayal is really, it ends up being a key trial theme usually because it's so strong, it permeates the entire case. But that doesn't mean it's necessarily the right business decision from the beginning. And so if you can have that moment from the get-go of stepping back from that and asking really what makes sense for your company, it can really save a lot of litigation heartache. In terms of concrete steps for pre-litigation steps, I put some on here of just the basics of like, what would you do if you think that you might bring a lawsuit? You want to preserve electronic data and electronic hardware. You want to interview people about what happened. You want to involve counsel to preserve any privilege or work product. You can do a forensic investigation. That's quite common. That often requires the use of an outside vendor, but you can get images of the computer hardware. You can do a lot of really interesting things with forensics in terms of seeing when documents were accessed. If 4,000 documents, if the person who left accessed 4,000 documents on their last day, you might have a problem. That kind of thing. You can tell usually with a forensic investigation, and then you can send demand letters. Yeah, Carol. On
the forensics, one of the things we do is we do train people so that they don't do that when they're exiting. And we train people on, look, when you download documents, when you move documents around, we're not monitoring you when you're doing that, but understand that we know when it's being done. And it's I say it in a nice way because, as people may want to leave, we know what documents go. And sometimes you can say that in the offboarding, I just want to make sure you haven't downloaded any documents. There may be some things, your personal stuff, let's go through that. But I just want to make sure you're not in a position where you've downloaded a bunch of documents and we're going to have to come back and ask you what you downloaded, because that sort of makes that whole situation, diffuse it before they walk out the door.
Yeah, that's a great tip.
Yeah, and I would know there's a couple of the systems that we've used historically, NetDocs and Dropbox. They have active notifications, and you can set sort of a notice that comes out as to when somebody has exceeded a certain download amount. And so if you see somebody starting to download a whole bunch of stuff and that's unusual, that can be a red flag for you to take a quick look or have a conversation with somebody. Because maybe they're, getting ready to leave, or maybe they're just working on a project where they're reorganizing files, so there could be a perfectly innocuous reason for it, but,
right.
There are things that you want to know and look into.
Right, that's a good point. There could be a really innocuous reason for all those files to be moved. Maybe they're just sorting things to make things nice for the next person, but
right.
It does raise a little bit of a red flag when you get into it from a litigation perspective.
And Amelia, since we have lawyers on, I just want to raise another red flag specific to lawyers. A lot of times we have form documents, and we see that even in law firm situations where form documents move from place to place, then we see it as a form that we're not going to disclose the information in the form, but we've worked on this. I just red flag to lawyers that can be a trade secret that you're taking in-house, and One of the things you can do, I moved from one company to the one I'm at right now. There were some things I wanted to take with me that I felt were not inappropriate to take. So I went to the organization and I said, I'd like to take some documents. I'll do a log of what I'm taking. I'll print them out. And then you can sign the log to say, yes, it's fine, you take this, so that there was no misunderstanding now of what I was taking. And it really was some form things that I wanted to take with me, and they felt that was fine. And I got it signed off and it was no problem.
That's a really great insight, Carol. I really like that. Sometimes, you know, as lawyers, we sometimes don't think about how these laws can apply to ourselves and when we move from place to place, but it's definitely a big concern. And sometimes it's just as easy as having a conversation with someone ahead of time so that there's no misunderstandings. I put in the slides some preliminary remedies. I'm going to skip these, but you'll have the materials, I think, after the fact. And I want to just close. We're 10 minutes in, but I don't see a lot of questions, so we can keep going. It's good. What do you do if you receive a demand letter alleging that your company has stolen trade secrets? So I'm going to go to this pre-litigation steps, but again, John or Carol, what's the first thing you think to do when you get a demand letter? How do you respond?
So, I kind of go back to the beginning and, sort of look at it, well, what is it that they're alleging we have? Does it fit the definition of trade secret? How did we come by the information? Because it could be that, we independently developed something that was very similar and they just think that we developed it that way. To kind of sort of, take that sort of very objective approach and methodical approach to figuring out what the information is, how it came to your company, and making sure that you've looked at that. If we find that there's a potential problem, obviously you'd want to look at engaging outside counsel, figuring out, is there a relatively quick cure to it? So obviously if you're having conversations with the other counsel on the other side, it's like, hey, this new employee came over, they brought us this information, they were told not to, we've destroyed it all, whatever it might be, right? I mean, there are sort of shortcuts, I think, to avoid the litigation before it gets really heated, right? And try to look at taking those efforts.
Yeah, and that goes back, right, as John said, to training. So when we do training, we remind people that if you get something sent to you, even if you didn't ask for it, that's sensitive, we have a process to note that stuff and note that we destroyed it, because it happens to everybody. Somebody will be sending information and inadvertently fill in to somebody in our organization when it was supposed to go to a competitor, or they might send something to the finance department. So that's an important element, because you cut it off right then. So if a demand letter comes in, you say, here's the process we followed to destroy that information. We did not use it, and the like.
I think from a litigation perspective, it's so important when it involves trade secrets to really be responsive to demand letters. I think a lot of times attorneys who don't focus on trade secrets make the mistake of throwing the demand letter in the trash and saying like, oh, they'll pound sand, they're never going to sue. That's usually not a great approach, because it can just really draw the litigation and seem like you're hiding something. It's much better if you have good processes in place to just be really transparent and start that kind of dialogue. That usually, if your goal is to diffuse the situation, that's usually the best way to do it.
One other thing too I'd mention is that, if it is going to, go into litigation, making sure that the litigation hold document that you have is comprehensive, make sure it covers all of the potential areas and things that you need to preserve, and also make sure that it goes to the right people, in particular your IT department. That tends to be where, who has control over a lot of those kinds of things. So that's also going to be very important.
Right, absolutely. That's obviously the first critical step. I put on here a little bit about considerations with litigation. I think the most important one is that damages, trade secret damages, can be hard to prove, which usually means that trade secret litigation is very expensive for very little kind of payout, which is something to think about, again, when you have those initial conversations about whether litigation is actually worth it. And then I put in a few slides here. I'm just going to touch on them quickly about criminal trade secrets, which is there are criminal penalties for trade secret misappropriation. This has there's been an uptick in federal prosecutorial interest. Here's a couple of examples. I think most recently, especially if you're out here in California, the Waymo versus Uber case with Anthony Lewandowski, the engineer, being indicted for misappropriating trade secrets when he left Waymo for Uber. But again, from an in-house perspective, this is a tool that you can use, to remind your business people that this is really serious business, and not just limited to company liability. So I think we'll just end with a couple of tips and takeaways. Carol, do you want to just kind of go through a couple of the tips here?
Right. Again, for us, it's the culture and being able to, in a respectful way, address mistakes that were made when you see them and not shame about it. But, I always say to folks, not everything, you don't know everything. So if something went a little awry and something wasn't protected, let's fix it going forward. Let's use that as an opportunity to train and to just remind people that what you're doing within the organization has huge value. It's value to the organization, and we need to keep that in our organization so that we can be the most successful aircraft leasing company around. And it's just this living, breathing thing within the organization that you bring up when opportunities arise, and also creating opportunities. We have a lot of meetings in our culture of companies in the U.S., and you just ask for time as the lawyer. And sometimes it's 5 minutes is enough. They're like, oh my God, the lawyer's going to train us. Don't even call it. I just want to give you an update. Or I saw a case and you want to just let people know about the case. And you just keep it as this constant dialogue.
Right. John, do you have any closing thoughts? And then we'll see if there are any questions.
Yeah, the only thing I would mention is, when we do trainings as legal, I always try to make them fun and engaging, using real world examples, some of them rather absurd, because those are the kinds of things that stick in people's minds, and try to get people to participate in it and make it really relevant. Those are, so if you're going to go through the effort of doing the training, just make sure that it's something memorable, worthwhile, and people aren't, bored out of their minds. And so that's always really helpful. And then, the other thing is, do the work at the front end, know what your trade secrets are, make sure people understand how to identify one, and then, take the reasonable efforts to protect them. Doing the work on the front end makes everything on the back end a lot easier.
Definitely. So this hour has seemed very, very short. We have time for just a couple questions. If you do have a question, please type it in the question and answer box now. We have one question about going back to kind of the definition of the trade secret, and the negative, a quick question about the negative information and what is what's competitively sensitive, maybe about negative information about customers not doing something. So Carol, maybe you could speak to that.
Well, you may have done or had relationships with a customer where they provide you information they're not providing to someone else. So there's a whole compilation of things that come in to what makes you think, one, a customer's a troubled customer and how you're going to handle it. And so if you're having specific confidential conversations, and you have background information that everyone else doesn't have, you have competitively sensitive information. In our circumstance, we've been in the aircraft leasing space for 40 years. Some of the airlines we do business with, they're 35, 25-year relationships that you build up over time, and you compile this information that is competitively sensitive. So when they're struggling, you may have an analysis of how they're going to come out of it, or what you think the risks are, and that's competitively sensitive, and you don't want that out, for example.
Right. Okay, great. Thank you. We have one question about monitoring. So what kinds of monitoring software might someone use? At first, I would say you want to be sure that the fact that your employees are being monitored, they need to know. That needs to be in your employee handbook or in your policies, so that they know that that might be happening. Maybe John, do you have thoughts on monitoring, sort of software monitoring solutions?
Yeah, I mean, other than a couple of the ones that I've mentioned, but in particular around file storage, so NetDocuments has a pretty good ability to, segment, monitor, who's doing what and how often. Dropbox is very similar to that. But there's, a wider monitoring process that goes on. So, your IT folks will be monitoring internet usage. They can, figure out if there's people that are, using a lot more, a lot less. There may be limitations on it. And you're right. I mean, in terms of letting people know that if they're sending emails that, the company, they're company emails, if they're the company property, and they're going to look at them, right? I mean, and I think that's, I've had people that it's like, well, wait a minute, no, that was a private email. So in particular, if you're using company property to access your personal email, right? And you're sending stuff, I mean, even that can end up being monitored. And so, make sure that people know that. But, we've caught people that are, planning on, going to a competitor through those kinds of monitoring efforts. And so you've been able to sort of head off some of the access to information and, making sure that, they're not taking stuff because you catch it early enough. So.
And one thing I learned is that a lot of times you have a software package, whatever you're using, and it has items that can be turned on or turned off, right? And so sometimes you find out from IT, well, we just never turned that on. And you're like, gosh, I wish I knew that. Or I wish I knew that whatever, the Microsoft suite had this capability, because I would have recommended turning it on or turning it off, right? And that can come up, in a lot of different avenues. And sometimes it's just even sitting down and talking and saying, well, what kind of capabilities do we have without spending another dime? Have we turned them on, and what's the ramifications for turning them on? And that's a really good conversation to have with your IT. And if they don't know, sometimes you can say, hey, what if we got on a call with the rep for, whoever's selling us the software, to find out what other things we could be using within it to make sure we've got the tools if there is a problem, or to head off a problem. Right,
absolutely. Well, there are no more questions and we're out of time. We're about 5 minutes over, but this has been a great panel. I want to thank our panelists again. Wait, I have a thank you slide. Today's speakers. I want to thank our panelists again for their time and their great insights. Carol and John, thank you so much. I want to thank ACC Georgia for hosting us. We really appreciate it, and we really appreciate your time viewing from your workplace or your home for watching today. We really appreciate it, and so I hope everyone has a great day. And again, the code is grape soda, and you'll want to email it to Ellen Hotter, whose email is in the chat. So thanks very much. And I guess that's it. So have a great day.
Thanks, everyone. Bye.
Thanks, everyone.
Bye.